Part 4. The key provisions relating to intellectual property rights. A patent exists to protect new inventions and covers the following: how things work, what they do, how they do it, what they are made of, and how they are made. The purpose of a patent is to give the owner the right to prevent others from making, using, importing, or selling the invention without the permission of the original owner. To be classified as an invention, it must be new, it must have an inventive step that is not obvious to someone with knowledge and experience of the subject, and it must be capable of being made or used in some kind of industry. However, it must not be any of the following. It must not be a scientific or mathematical discovery, theory or method. It must not be a literary, dramatic, musical or artistic work. It must not be a way of performing a mental act, playing a game or doing business. It must not be the presentation of information or some computer programs, so some are allowable, some are not. It must not involve an animal or variety of plant, and it must not involve a method of medical treatment or diagnosis. So it must not be against the public, against public policy or against morality in any way. If you or your company meets these requirements, then you may decide to apply for a patent. If you are then granted a patent as a result of that, you must continue to renew it after the 5th year for every subsequent year up until the 20th year of protection. This is done through the UK Intellectual Property Office and involves this particular organisation in receiving and examining patent applications, granting patents, maintaining a library of granted payments, correcting defective payments, cataloguing and storing documents which are placed in relation to patent applications, and also collecting patent fees. This is of course extended into Europe, where it is controlled by the European Union Patent Office and does involve all 27 member countries. Copyright. Copyright applies to work which has been recorded in some way and involves rights to literary, artistic, musical, drama, films, sound recordings, and typographical arrangements. The author has specific rights to the work and prohibits unauthorised actions. Also, the author can take legal action against infringement or plagiarism internationally. Trademarks. A trademark can be a name, such as Nike, a word, such as nylon, a slogan, just do it, a design, for example, the Guinness Golden Heart, a symbol, a Nike swoosh or tick, or other unique device. It identifies a product or an organisation and is very useful in that respect when people buy, like, and wish to rebuy and make sure they buy the same brand, the same product from the same company again in the future. Trademarks need to be registered by country. They're registered on a country-by-country basis, separately and individually. However, there is now a pan-European Union member country protection known as a community trademark. So within the EU you can have one trademark protection across all member countries. The trademarks are normally defined by use of a TM after the name, letters TM, or an R, the letter R, in a circle after the name of the branded product. Problems often do occur as to who actually owns a piece of work. For example, if it were an advertisement, would it be the person or the organisation who authored the work? However, they may be a freelance person who acted as the creative person in this instance. It may be the organisation who employed this person, this freelance, who created the idea, the advertising agency, Or it might be the eventual user, beneficiary, the advertiser themselves. So who actually owns the idea? The person who created it, the person they worked for, or the ultimate user, the advertiser? This will ultimately depend on the agreement or contract that was arranged, discussed, agreed and signed in the first instance. However, in the past, some inventions have been stolen. Again, there have been examples where inventions have been copied. Also, some inventions have in effect been given away. An example of one that was given away would include the World Wide Web. The person who created that allowed it to be used by others for no payment at all. So, if you or your organisation do have a great idea, you must protect yourself by submitting it to the appropriate organisation to gain proof of ownership of that idea.